Ladies and gentlemen, welcome back to the People's Law School. I want you to know this is the best kept secret around. And also let me mention to you that we bring to you the best lawyers in America. But like the speaker at the last session said, we don't tell lawyers jokes. And those of you who have been here before know why. It's because lawyers don't think they're funny and other people don't think they're jokes. Remember that. All right? In honor of my friend D. Thomas, the late D. Thomas, who always said that, and we miss him. But welcome to the People's Law School. Tonight we have Kerri Johnson Smith. Kerri Johnson Smith is Huntsville's own. She grew up right here, graduated as a valedictorian of her class, went on and received her chemical engineering degree at the University of Alabama, and then her law degree, practiced law down in South Alabama for a while, and has been a litigator for about almost a quarter of a century. She's an excellent lawyer. We have seen her in what I call the heavy hitter cases. She has, because of her technical background, done some very complicated chemical and toxic cases, terrible fire and burn cases. She's lived quite a life. I was amused to note that while she was in high school, she was an exchange student in Colombia. When she was in college, I know she worked in the oil fields of Louisiana. And then just a few years ago, she went over to Kazakhstan and brought home her 5-year-old boy, Daniel. And I know that she sent several of us emails while she was over there, and it was quite stunning. She said, you just don't realize what it's like when you see there are almost no toys for the children. She said the poverty level is incredible, and she said it was quite a journey. But Kerri's life has been quite a journey, and she does a well of a job, and I am proud to call her my friend. It is my honor and privilege to present to you Kerri Johnson Smith.
Thank you for having me back. I always enjoy it, and we've got such a crowd tonight. I apologize for not bringing enough handouts. It really wasn't because we ran out of paper at the office. So I will see if Joanna can take care of that, and we'll have some for you next week. Now you're about to see a real lawyer doing a pressure play here, because as I walked up somewhere along the way, I dropped my paper. So you're going to see somebody who does what lawyers have to do sometimes in the courtroom. I'm going to wing it tonight. Let's see what I remember. I was actually very excited this year, and so I'm going to start with what I do have in front of me. I was very excited this year to realize that I'd have some new things to talk about. I want to talk about the 2008 amendments to the Americans with Disabilities Act, and I want to talk about the Lilly Ledbetter Equal Pay Act, both of which have been in the news and are just very exciting developments. Of course, our dear Alan informed me that he had touted me all week long as giving the great sex talk. So sex sells is what he says, and of course, you know, it does. I always enjoy speaking about sex harassment cases because, as Mr. Morris spoke earlier about, that's where my passion is that women are treated equally in the workplace, as well as other folks who may be a minority in the workplace. And increasingly, we're seeing, for all you white men out there, we're seeing reverse discrimination cases. So anytime someone is discriminated against in the workplace, that's what I like to redress, and that's what I enjoy and was part of my passion. So we will get to that this evening. But I'm going to start with, as I said, what I have in front of me. And some of this new law that we've just recently seen. One thing that I did, and I didn't realize when I did it how unique it was, but several years ago, probably 1995 maybe, I tried what I believe to be the first Americans with Disabilities Act case in this area to a plaintiff's verdict. I didn't know it was special at the time. Someone told me later it was reported in one of the publications in New York. But it was very exciting when the Americans with Disabilities Act was promulgated, because it just seemed like the right thing to do to redress workplace discrimination against disabled people. There was all sorts of really good reasons for people who were disabled but willing and wanting to work to be able to do that. To not be on Social Security, to not be on the welfare rolls, to not be a burden to their family, to society. And it seemed like such a small thing to say, essentially, as the ADA does, that an employer who can should give a helping hand to someone who is disabled, modify the workplace in minor sorts of ways that would really inconvenience no one and cost little money, if any, so that people who want to work can. Well, that was the idea. And I pulled my notes that I had from a speech I gave right after it was promulgated, and it said, well, I won't even tell you what I said the odds were of winning these cases if you got to the jury, because they're very high. My prediction would be they would be very high, because who could argue against giving a helping hand to a disabled person who wanted to work, didn't want to be on welfare? And I think the defense bar assessed it the same way. If you got to the jury, then plaintiff was going to win. In my one case that I got to try, that is exactly what happened. Well, as defense lawyers are wont to do, they then set out to make sure that plaintiffs did not get to the jury. And each and every word in the Americans with Disabilities Act was litigated time and time again in many, many courts and on up to the Supreme Court. And if you look at this bulletin or this handout that I just, for those of you that have the handout, it gives you a history of the ADA and how it was changed over time to be something other than what Congress intended when it was passed, and how it finally, Congress said, okay, enough, this is not what we meant, and came in and changed the ADA to reverse two major Supreme Court cases that basically gutted the intent of the ADA and made it almost impossible for anyone to win an ADA case. Under the ADA, we have a definition of disability. And of course, in order to bring an ADA claim, you have to be a qualified individual with a disability. Disability means a physical or mental impairment that substantially limits one or more major life activities. And again, as I said earlier, each one of these words, literally, was litigated, and usually it came out against the plaintiff. Substantially limits was one of the terms that Congress finally had to redress the definition that was given by the courts. Major life activities was another one. But a disabled person under the ADA was a person with a physical or mental impairment substantially limiting one or more major life activities, a record of such an impairment, or being regarded as, being perceived as having an impairment, even if you didn't have one. The 2008 amendments did not change that definition. That has remained the same. But it did change the meaning of some of those words as has been given by the courts over the years. Substantially limits was determined by the court to being someone who was significantly restricted from doing the sorts of things that we normally do, significantly restricted. And Congress said, wait, that is way too high a standard. No one can get to court, no one can win these cases, and disabled people are not being allowed to work as we intended them to do. So in the 2008 amendments, Congress has directed that the EEOC come up with a new definition for substantially limited, and it's going to be an easier definition. The way these cases were brought about was that plaintiffs were bounced out of court based on the fact that they were determined to not be disabled. And as it played out, someone, for example, with epilepsy who took medication and generally didn't have seizures was determined to be not disabled. Yeah, exactly. Someone with brittle diabetes who took insulin was determined to be not disabled. And the court said, this isn't working. Mitigating measures were required by the courts to be taken into account when determining whether or not someone was disabled. And the 2008 amendment says, no way. Mitigating measures such as medication, medical supplies, equipments, low vision devices, assistive technology, aids, auxiliary aids or services like in some cases maybe a dog or an animal that assists in some workplaces now. Those things are not going to be taken into account anymore in determining whether or not someone is disabled. The only thing that is going to be taken into account are eyeglasses. If you're wearing eyeglasses, then the court will look at you, at how you see with your glasses on as opposed to with them off. But that is the only mitigating measure that's going to be allowed. So, to sum up, the changes are that substantially limits is not going to be as limiting as it was before, and we're going to ignore the effects of your medications or other ameliorating measures whenever determining if you're disabled, except for eyeglasses. We're all going to have to take that vision test with our eyeglasses. Major life activities, which have to be restricted in order to be determined whether someone is disabled, have been expanded. Again, using the example of diabetes, someone whose whole endocrine system was completely not functioning was not necessarily determined to be someone who is disabled. And the courts have, or Congress has come in and rectified that because that had been excluded by the courts. And the two cases, in case anybody's really interested, were Sutton versus United Airlines. That's the one that said you had to take into account the mitigating measures to decide whether or not somebody was disabled. And Toyota Motor Manufacturing, Kentucky versus Williams, which redefines substantially limits to be very restrictive, and Congress said no, that's not what we want. One case where the 11th Circuit was actually in a position of being ahead of the law was in reasonable accommodations for someone who is merely perceived as being disabled. The 11th Circuit had come out and said the ADA protects someone who needs a reasonable accommodation under the law if they're being just merely perceived as being disabled. And the courts, or Congress, has backtracked on that one and said, no, no, if you're merely perceived as being disabled, then you're not entitled to an accommodation in the workplace. Other issues that have been addressed by Congress is that if you have a disability that is episodic or it's in remission from time to time, you're still disabled. Now, something that people want to know, I don't know, do we have any small business owners in here? No, well, any employer with 15 or more employees is subject to the Americans with Disabilities Act. And what employers often want to know is, you know, what do I do with this kind of information? Well, one of the things that you do now with these new amendments to the Act is that you presume people are disabled. Do not presume they're not disabled, presume they are if they bring something to you, and accommodate them if you can. It's really not an accommodation that is supposed to be damaging to the business or to anyone's business. It's not an accommodation that will change someone's job functions. If you can't do the job, you can't do the job. But in the case that I tried, and this is the example I always use because it just seems so simple, the fellow needed 2 accommodations in a workplace in an 8-hour workday. He had to start a cart pushing. Could push it from there on, but had to start the cart pushing. And there was always somebody around to help him. And he had to lift some milk down from a high shelf one time a day. And there was always somebody around to help him with that. Those were the only two things he couldn't do. And he got fired. And of course, we won that case. In the intervening years, I have a feeling that that case would have gotten bounced out of court. But now, under the new amendments to the ADA, I think that that case would be in court, as it was at the time. Does anybody have any questions about the Americans with Disabilities Act before I move on to Lily? Go ahead.
This perceived part there, the 11th Circuit, San Francisco.
11th Circuit is us. 11th Circuit is us. Georgia, Florida, and Alabama. And the 11th Circuit is located in Atlanta. If you go over, and I have gone over and argued there.
Well, this perception thing, I don't understand that.
Someone being perceived as being disabled when they're really not.
Be disabled.
Mm-hmm.
How do I do that?
Well, gosh, a way to perceive someone as being disabled.
Is that because you can't do some work?
Perhaps they look different. Perhaps they walk a little differently. But in fact, they aren't any slower, they aren't any weaker than anybody else. Maybe objectively they are not disabled, but by the way they look or talk or just something about them, you think they're disabled. You perceive them as, and you don't like them, you don't want them in your workplace because of that. That is perceived as being disabled. You don't have to accommodate that under the new act. But if you discriminate against someone because you perceive they're disabled, then of course that is that's subject to redress in the courts. Anybody else? Yes, ma'am.
I have a question in regard to soldiers returning with this PTSD, traumatic stress syndrome. Would that be considered a disability in the civilian world?
It may very well be. I have, of course, these are all brand new. But if it is a disabling condition that affects a major, well, let me look here at my notes. A major life activity, and working can be a major life activity if you're affected in the way that you work. Sleeping. PTSD folks have trouble sleeping. So maybe so. Yes.
So like an insomniac could be considered like a disabled person because they can't sleep.
Yes. Narcolepsy. Narcolepsy is a disabling condition, and in certain cases that condition may have to be accommodated in the workplace, provided that the person can do their job with or without an accommodation. I mean, you have to be able to do the job, and it has to be the sort of accommodation that is not too onerous for the business. I mean, obviously you can't put the business out of business accommodating people. Yes?
In the accommodation, are we talking about a physical thing, or could we be talking about scheduling, or could we talk about the time someone's required to stand, or things like that, or all those?
Could be any or all of those things. A reasonable accommodation is not that someone else does your job. That is not a reasonable accommodation. A job does not have to be restructured for someone. You don't have to change somebody from A shift to B shift because, you know, well, normally it'd be like B shift to A shift, you know, or something like that. You don't have to give them a different job in the company to reasonably accommodate them. But it could be an assist device. For an example would be the computer assistance for people with low vision. It could be, you know, my example where someone was always around already. You know, they didn't bring somebody into that particular work area to assist, but there was somebody right there all the time who could say, hey, will you help me a second? That could be an accommodation. It's really up to the employee to bring the need for the accommodation to the attention of the employer and pretty much to solve the problem too. It is not for the employer. It's supposed to be an interactive discussion, but it's not really the employer's job to, identify that someone's disabled and then figure out what they need and then give it to them without asking. The employee has to be proactive in this situation. But disabled people who want to work, at least in my experience, pretty much are proactive. So anybody else? Yes?
Is obesity considered a disability?
Obesity. Is obesity considered a disability? And I do not know. I do not know. That's an interesting question. I'll have to look that one up for next year.
The case that you described earlier, this person couldn't put something up on the shelf because it was too heavy or too high, and they had to have help.
High and heavy.
High and heavy. Was he the same classification as the other people who worked there, or did he have a different job classification?
Same. The same.
But he was expected then to do something that should be, you're saying that it was his job to do that then?
It was his job to do that, but it was not an essential function of the job. In other words, it was a little small, tiny piece of the job.
But he couldn't do it.
Couldn't do that without help. And there were always people, and it was the sort of thing that it was common for one person to say, hey, give me a hand here. Anyway, hey, give me a hand here. And that's what the ADA is all about. Just a little bit of a helping hand to allow people to keep their dignity and to work and be productive members of society. Yes?
Does this apply equally to people who already have a job and people who are applying for a job?
It does. It does. Under Title VII, which is the Title VII format that we've talked about so many times before, you can bring a claim if you are discriminated against in any of the terms, conditions, or privileges of employment, including applying for a job, including being not selected for a job. And if someone feels that they've been discriminated against, then, as we've said in other years, you must file a charge with the EEOC, the Equal Employment Opportunity Commission, down in Birmingham, within 180 days of the alleged adverse employment action or adverse employment decision, in order to protect your right to sue. And then the EEOC does its thing. We won't go into that, but they do whatever they're going to do, and you just have to wait for another 180 days. And then after that period of time, the EEOC will either issue you a right to sue, or you may ask for a right to sue. Then you have 90 days to bring a lawsuit in federal court. That's how that process works. And that's what I do every day of the week. Yes?
You said non-selection, but non-selection would not be a criterion, would it? Wouldn't you have to prove that it was because of disability?
You must always prove it is because of. It's discrimination because of. Either ADA or in sex discrimination, race discrimination, age discrimination.
Would not necessarily be the case.
Mere non-selection is not necessarily a case. No, and I see this all the time, and this is a refrain I speak to quite frequently, and every now and then I'll even get a lawyer who call me on behalf of their niece or daughter or high school classmate or whatever. It's different when it's you, but the law in the state of Alabama is that you can be terminated or not hired for any reason at all. Good, bad, indifferent, unfair, wrong. You can just plain be terminated or not hired. We have no employment rights in the state of Alabama unless you fall within the purview of either a federal statute of protection in employment, which would be Title VII. You cannot discriminate because of age, race, sex, national origin, disability, etc. Or we now in the state of Alabama have a statute that protects age. It's all we've got, but we've got an age discrimination statute in the state of Alabama now. Otherwise, you can be discriminated against. You can be discriminated against because you have blue eyes or blonde hair or you know, a whole wear a purple shirt, or because someone thinks that that you were the guy that once fired his brother-in-law, even though that's not true. Yep, they can fire you for all those reasons. They can fire you to give the job to their brother-in-law if they want to, so long as the brother-in-law is not younger, and that's the reason. At any rate, yes, discrimination always has to be because of, and you must prove it is because of your age, because of your sex, because of your disability. Otherwise, you will not have a claim. Anybody else? Okay, well that leads me into Lily from Gadsden, Alabama. How many of you have you heard about the Lilly Ledbetter Fair Pay Act? Oh, good. Do you all understand it already? Should I just skip this part? No? Okay. Well, Lilly Ledbetter was 70 years old when she retired. She worked for Goodyear Tire in Gadsden, Alabama. And I believe she was a supervisor. And about either right when she retired or right when she was about to retire, she got an anonymous letter. It said, "Hey Lily, do you realize that all these many years you've been paid a whole lot less than the men who you do the same job as, you work right alongside?" Of course, she did not know that. So she filed an EEOC charge claiming to have been discriminated against because of her gender, in that she had received less pay from 1979 to 1998. It's a long time. Now, any mathematicians in here can do the math, but not only was she receiving less pay, but then she got probably less Social Security. She had less contribution opportunity to her pension plan or 401k. It just snowballs, and although we've all gotten a rude awakening about compounding in ever-increasing accounts, the idea is that over time your assets build and they compound, and so it was a pretty significant sum of money that she would never have because of a decision made years and years ago to pay her less and then continue to pay her less. Raises are given on percentage frequently. Well, 3% of less is less, and it compounded through the years. I see some people out there doing the math. So anyway, Lily files her EEOC charge and ultimately sees, and it wends its way all the way up to the United States Supreme Court. And the United States Supreme Court said, Lily, you didn't file your EEOC charge on time. The adverse employment action occurred all the way back in 1979 or 80 or whatever, the first year that you were not paid as much as the men. And thereafter, you know, it was just all carry on. So you would have had to have filed within 180 days of that initial decision to pay you less than the men. Of course, that was 20 years before. So she was out. Pardon me? She didn't know. Yeah, exactly. Too bad. Didn't care. I think it was Justice Alito that did that. But anyway, so Congress said, "Oh no, that's not fair," and so the Lilly Ledbetter Fair Pay Act has now been enacted, signed into law, and it has changed that Supreme Court case. It has changed the law as set out in that Supreme Court case to say that each separate paycheck is basically a new decision to pay less. And so as long as you're within 180 days, which is how it ought to have been. But you see how these employment cases go in the courts. Now, I heard Mr. Morris speak earlier about contingency fee cases and how those cases are difficult, and that's why it justifies a percentage fee. Well, I do, as Alan said earlier, I do what boys do. I do those car wrecks and those products cases. But I also do employment cases, and I do those on a contingency fee also. And I do them that way because no one can afford a lawyer for, what, 10 years to get a case all the way through the Supreme Court. And each individual word frequently in the statute, each individual fact is fought and fought hard in these kind of cases. So, so that's what you do, and you have to have passion for it. And you have to have some fortitude and some tenacity. And Lily Ledbetter did, because of course she won't benefit from this at all. But she got this bad decision changed. We see these decisions in the courts, I think in some measure because the courts are overwhelmed and they can't quite believe Congress means for them to handle all these employment cases in their courtrooms. But of course it's the only way to get fairness in the workplace, frequently. Somebody had a question? Ma'am?
I was going to ask you what she got paid, and they said she didn't get anything.
She didn't get it, no.
Even the last year's pay, she didn't get it?
She was out. It's too late for Lily. She did this, and I think in her news conference she said she did this for her daughters and granddaughters and nieces and all the women coming behind her.
So the lawyers didn't get anything?
Not a thing. Not a thing.
So the bottom line is it has to be within the 180 days or you're out?
That's right. It has to be within the 180 days or you're out. In this case, the law was changed to count the 180 days per paycheck as opposed to from the point of decision way back, 20 years ago. But yes, it always has to be within 180 days. And I always call it for my clients, I say within the decision, from when you knew, not from when it happened, but from when you knew. I always err on the side of caution. Yes?
Wouldn't it be true that her employer made that same decision over and over every year at annual raise time? In other words, 3% is 3%, like we were saying, but if you knew an employee was not being fairly paid, you have a decision whether you're going to change the problem, change the compensation.
Well, the United States Supreme Court, in its infinite wisdom, did not agree with that. However, Congress agreed with you. So that's the best we can say. And I agree with you if that matters.
She's on retirement from Goodyear now,
She is.
and her retirement is based on her salary while she was there. So her next retirement check, she ought to file. Yes.
Maybe her lawyers will do that for her. You just never know. You just never know. Okay. All right. Well, moving on from Lily, does anybody have any more questions? Yes.
You have a case now where you have older employees who are getting close to retirement age.
Mm-hmm.
You have a lot of companies cutting back on employees or minimizing their staff. And that older employee that's maybe been there 20 or 30 years, is getting close to retirement age, is let go, and you said before that they can let you go for any reason in the state of Alabama, that you'd have to prove that you were discriminated because of your age, and where they might replace two people with the salary that you have accrued or built up to that point. But that's just tough luck unless you can prove an intent.
Well, salary, money is frequently the reason why these decisions are done. Just because your older employee makes more than the younger ones, that will not protect an employer. But frequently I see where the employer has hired very fine defense lawyers to plan out their RIF in such a way that it's awfully hard to prove it was because of age. The most important thing that anyone can do, and I have a case like this that just came into the office where the employer was not too smart. Probably economic times were so poor they didn't go consult that high-priced defense lawyer. But in this case, the employer made a decision to not train a certain employee. The discriminatory act, the adverse decision, is the failure to train. What I see frequently is there's a failure to train, the employee doesn't want to rock the boat. More than 180 days later, their rift because they don't have the requisite skill, it's too late. It's been too late in those situations. I have a case in the office where, for whatever reason, there was a failure to train, and then within 2 months there was a rift. So I've been able to catch both acts within my 180 days. But it's very tricky. I am one of the few lawyers in town, especially litigators, who will counsel people. And I do it just because it is so very needed. But not a big part, but a fair part of my practice these days, I will see people who are on the leading edge of a problem at work, if they are wise enough to pick up the phone and call me. It's not terribly expensive to come in and spend an hour, but I'm able to counsel people in such a way that they know how to act, they don't miss their time, they lay their paper trail if something is coming up that they see coming on the horizons. And I have found that people frequently know that it's like they have a sixth sense. They know when there's going to be trouble at work. They need to come in. The ones that it kills me are the ones who come in after they've quit. They knew their employer was going to fire them, so they went in and quit, and then they call the lawyer. Can't do anything. You gotta let them fire you. And I counsel people frequently on how to get through that process in such a way to preserve your claim. But send people in to see me or see someone else, if you can find somebody else who'll do it, who have employment problems, who are being set up. A lot of people are being set up with disciplinary action after disciplinary action. They don't know how to respond. If I get in those cases quick enough, sometimes you can save the job. That's best. Jobs are always better than lawsuits. But if not, maybe I can help preserve a claim. Yes, ma'am.
If Lily today had filed in a timely way under the new Lily Ledbetter law, would she have been able to reach back all the way the 20 years, or would she only have been able to go back as far as the statute of limitations?
I think you can go back 2 years preceding the filing of the EEOC charge.
Okay, so she would have lost then the first 18 years.
I believe she would have lost, but I believe you can go back 2 years from the date of the filing of the charge for damages. Yes.
I'm getting too details. Could you mention the difference between Title VII and Title V? And in this community, there's a lot of Title V.
Beyond the scope of 3 minutes. Well, that'll have to be for next year.
Well, is there anybody that deals with Title V, which is government employees, basically?
Yeah. There are a couple. I've even done it a few times. But it's really a very highly separate, specialized area. Yes?
It's kind of like a follow-up question to her. So, would Lily get to the snowball effect of the past 18 years, or would she only get just the amount of pay and the retirement costs and all of that of just the past 2 years, or would she get the sum total of the 18 years?
The question is, were the circumstances different and Ms. Ledbetter could file today under the new act? Could she reach all the way back 20 years? And my answer is, I believe you can only go back 2 years from the filing of the EEOC charge to get your damages. I think that's all you can get.
You would still lose all that money.
You would still lose all that money. Yeah, waiting is never a good thing. Waiting is never a good thing. Okay, anybody else? All right. Alan, how much time do I have left?
An hour.
12 minutes.
I have 12 minutes left. All right, yes.
Off topic a little bit. If an employer fires you and they don't follow their own internal guidelines, do you have any recourse?
Well,
With the right to work law, probably not.
it's actually no rights to work. It's actually employment at will. This is how people get confused about this, and I'll do my best to explain it. The question is, if employers do not follow their own procedures, do you have a claim? Do you have a case? And this is how that works. Under Title VII, you first have to be a qualified individual protected under the Act, by virtue of your age, race, national origin, disability, whatever. You have to believe objectively that you've been discriminated against because of your age, race, sex, national origin, whatever. The way that employers utilize their procedures to try to defeat those claims is they come in and they say, as a defense, they say, we didn't discriminate against you because we followed our procedures. We did everything we do for everybody else. So that the employer's procedures are a defense for them. And following that procedure is something they set up as a way to defeat a claim that you believe that you have. Then you have to come back in as a plaintiff and say, oh no, they didn't follow their procedure. They're just throwing up a smokescreen, a pretext. They really fired me because of discriminatory reasons, and and this is why. So those policies and procedures, following them, help the employer to disprove a plaintiff's claim of discrimination. But they don't have to follow their procedures. There's nothing that says they have to do that. It's just helpful to them if someone claims. Yes, ma'am.
Do you have a right, if you get fired, do you have a right to know exactly why in writing? Or do you have any rights at all? It's just leave and that's...
Nope. Nope. No. You don't have a right to know why. You don't have a right to your personnel file. You really don't have any of those rights. And it is particularly, I find that my women clients have just the hardest time sitting there and getting fired, which is not pretty for anybody. But you really do have to let them do it. If you quit in advance of the firing, well then you quit. So how are you going to claim that you were fired for discriminatory reasons, or you were fired because your employer retaliated against you? Well, you quit. So coming to see me after you've quit is not necessarily the thing to do. All right, anybody else? Yes, sir.
Exactly how to ask this. How would Miss Lily found out that she was being underpaid if it hadn't been for that anonymous? And is there anything in the law you could get guidance on whether or not you're being underpaid?
The question is, how would Ms. Ledbetter have found out other than that anonymous letter? And is there anything in the law that gives you the right to find out if you're getting paid the same as the person next to you doing the same job? The answer is she wouldn't have found out, probably, unless somebody told her. And there's nothing that gives you the right to find out what the person to the left or the right of you doing the same job is making. And frequently employers don't want that information talked about in the workplace. They will often have a policy against it. So it's really catch-22. I think the Congress has done well with this law, but that's of course my personal opinion. Yes?
Congress didn't put any relief in, did they? I mean, their infinite wisdom didn't provide you a method to find out.
They didn't provide you a method to find out, no. What everyone else is making, and they didn't help Lily either. Yes, ma'am, in the back.
What areas and how would you advise us to document if we feel like it is true discrimination?
The question is, what areas would documentation be helpful if someone feels like they're being discriminated against at work? And how to document? Well, there are a number of ways. The first advice I'd give somebody is go see an employment lawyer. If you feel like you're being discriminated against, go pay your $200 or whatever it is, get an hour, hour and a half of somebody's time, lay your situation out, and get some competent advice. That being said, Documentation can be any number of things. If your employer has no prohibition against it, you may record in the state of Alabama any conversation that you are a party to, that you are a part of. You may not leave a tape recorder lying around to capture someone else's conversation. That is illegal. Don't do that. And this advice does not apply across state lines because I'm only an Alabama lawyer and other states have different laws. But you may record. And many times I have people come in with recordings and they're often quite illustrative. But you need to remember you are also being recorded. So if maybe you don't think you got heated in that conversation with your supervisor, perhaps the tape may tell a different story. So you do have to be careful. Nothing beats a diary. Go home and make a diary. It's very onerous though, and it's very hard to continue to work in an environment where you're having to write everything down every day. Yes, sir.
Wouldn't you recommend on those very professional companies do performance reviews, probably at least once a year, that an employee keep copies of their performance reviews so that when the time comes and they have this high level of performance and all of a sudden they get fired, they have a case. That's particularly interesting and when you get to age discrimination and everything. You with me? Do they do that anymore?
The question is, should you keep copies of your performance reviews? And my response to that is absolutely. Keep copies of everything to do with your job. Your employee handbook, your performance reviews. Keep it and keep it at home if you possibly can. And on a related note, if you're ever subject to disciplinary action and your employer says, sign here, well, read it before you sign it. It might say, I agree with this 100%, in which case, don't sign it. But often it says, I acknowledge I got a copy. Go ahead and sign it. If they give you a copy, that won't hurt anything. And keep it. And then best consult your lawyer. Anybody else? Yes, ma'am, in the back.
You said something that you could record things, but do you have to let your employer know you're recording the conversation?
Nope.
Okay, so in Alabama you can record it, hide it some way, but not necessarily.
The question is, do you have to let someone know that you're recording them in the state of Alabama? And the answer is no, not as long as you are part of the conversation. And the only caveat to that involves children and parents, which we won't go there. Yes, ma'am.
As far as vacation time or time off that you've earned working every month, can an employer make you use that to help them save money and paying you certain dollars because of maybe the company's not doing so well financially?
I'm not sure I understand. Is the question a use it or lose it policy with regard to a vacation?
You've got vacation that's saved up, that you're sick, your vacation, it's all in one bucket. And so instead of paying you productive hours every week, they make you take time off in order to help offset the cost to keep their establishment running.
You're talking about mini layoffs? Sort of? Furloughs?
They're making you take your vacation time off. So that
compensatory time.
Comp time.
They're going to make you take a week off because the company is going to be busy in August.
So you're working less than 40 hours.
Making it up with your vacation.
You're working, instead of working 40-hour work week, because you're a salaried, so instead of working 32 hours and keeping your time, they're making you work 32 hours, but instead of working that extra 8, they're taking it out of your vacation bucket and supplementing your income, which comes out of a different bucket.
That sounds like I would have to sit down with you and get that all worked out off the camera. Well, are you salaried or by the hour? You know, that salary is a nice thing sometimes, but sometimes it's not. It's kind of like having a small business. You know, it's nice sometimes, but when everybody's out sick and somebody's got to run the copier, guess who it is? Okay, well, you know, I have not addressed the teaser. I know. How could we have gone through a whole hour and not talked about sex? I mean, really. And I have all these, so I'll just give you the quick highlights since, as I told you at the beginning, somewhere along the way I dropped my very scholarly paper. I think it's in the parking lot out there. But I'm going to tell you what everybody wants to know anyway all the time. They want to know what they can get away with under the law. So I highlighted all that while I was sitting out in the hall, and that's probably will be our wrap-up. Now, I'm not recommending any of this, okay? But for all of you fellows out in the workplace who think if you tell a pretty girl she looks nice in that dress today, lightning is going to come down and strike you, and in addition to your wife divorcing you, your employer is going to hang you out to dry and you're going to get sued and lose your house. That's not going to happen, okay? The courts, as the courts have got very extreme with the Americans with Disabilities Act, to the point where Congress have pulled them back and said, no, this is what we've meant. In my opinion, anyway, the courts have gone further and further away from the intent of the discrimination laws, particularly in the area of hostile environment, sex harassment, hostile environment workplaces and sex harassment. Increasingly, the courts have said, well, this isn't severe and pervasive enough to be actionable. And that's one of the things that sex harassment has to be in a hostile environment situation. Now, if you're dealing with an assault, a grabbing, touching on private areas, something of that nature, then that's a whole different ballgame. But when you're talking about comments, leers, winks, rude and boorish behavior, the courts have really allowed more and more things that people wouldn't generally think of as being acceptable, and they're not acceptable, but they're also not actionable. And so, a recent case, I pulled out four key words: intimidating, threatening, leering was one of them, and it may have been touching. That those seem to be the keys where courts are finding them actionable. But this is the Mendoza case that sets the standard in the 11th Circuit, and as I said, that's our circuit. That's Alabama, Georgia, and Florida, seated in Atlanta. And these are things that people have actually done to women in the workplace, and the women have gotten bounced out of court. These were not, I won't call them acceptable, but they were not actionable. Oh, and this is one, this is my top one here. Repeatedly calling plaintiff a sick, to keep this a family show, B rhymes with witch, okay? Repeatedly calling the plaintiff that was determined to be insufficiently actionable as a hostile environment work claim, and it was because that is not gender related. Now, if any man in here has ever been called that name, raise your hand. That was not gender related. Insufficiently severe and pervasive, where there were repeated sexual jokes. One occasion of looking the plaintiff up and down, I call that elevator eyes. Stating there's nothing more in the morning that I like than honey buns. Suggesting an area of land be named Twin Peaks. Saying, weren't you just there at a particular biker bar? Dancing on the tables. Referring to the woman in question, just get that broad to sign it. Telling her she's paid great money for a woman, and apparently the lady's doctor was named Dr. Bosom, and that brought about hysterical laughter. The court said that won't do. That won't do it. Can't sue. Insufficiently severe and pervasive in the 7th Circuit, 9 instances of offensive behavior over 7 months. referring to the plaintiff as a pretty girl, and one instance of a simulated sex act. Not enough. Asking the plaintiff if she was in bed with someone. Not enough. Supervisor repeatedly asking about personal life, saying how beautiful she is, calling her a dumb blonde. Oh, that would get it for me. Asking her out on dates, putting his hand on shoulders, doing the I love you sign. Tried to kiss her once at a bar and twice at work. That was not enough. Now, the courts helpfully explained to us that expressing a hostile environment claim is expression of extremely insensitive conduct so egregious as to alter conditions of employment and destroy a woman's equal opportunity. Well, you know, I defy anyone to tell me that you can work when your supervisor is passing you 20 times a day doing the up and down, you know, the woo-hoo. And we have one case where, and this is the Mendoza case, which sets the standard. This is what the fellow did to Mendoza. He said, told her he was getting fired up looking at her, rubbed his hips against her hips, and of course was smiling and leering at the same time. Made a sniffing sound when stopping those elevator eyes at the private parts. None of this was enough to sue. So, as I said, I think that the courts have gone to the extreme in allowing what they call not acceptable conduct, boorish conduct, maybe offensive conduct, but not actionable conduct. I particularly enjoyed seeing in another case, the Gupta case, which is also 11th Circuit case, that asking a woman to join you at Hooters was not actionable sex harassment. So, y'all, I've really enjoyed it tonight, and I'm sorry I can't go on any longer, but maybe we'll pick up and do a little bit more of the area of sex harassment next year. You're welcome.